Question 46. Buyer Barney made a binding offer to seller Silas that Silas accepted in the proper manner. But then Barney changed his mind and refused to go through with the transaction. Under the statute of limitations, what is Silas's deadline to sue Barney in order to enforce the contract before being time-barred? A. 1 year, B. 3 years, C. 4 years, D. 10 years. Correct answer is C. 4 years. In California, the statute of limitations for a breach of a written contract is 4 years. This means that Silas has 4 years from the date Barney breached the contract, example, refused to go through with the transaction, to file a lawsuit against Barney to enforce the contract. Question 47. Borrower Brian defaults on a scheduled event in his loan agreement, his monthly payment. Lender Lenny then has the right to declare Brian's entire loan balance, all the principal amount still owed, due and payable without delay because of an IA, alienation clause B, forfeiture clause C, acceleration clause D, due on sale clause. Correct answer is C, acceleration clause. An acceleration clause in a loan agreement allows the lender to demand full repayment of the loan balance if the borrower defaults on any of the loan terms, such as missing a payment. It accelerates the due date of the entire loan. Exercising the acceleration clause is also termed calling the note or the call provision. Question 48. A broker is adverting under the name of XYZ Realty franchise. The broker's ad must also A. State that he is a licensed member of that franchise. B. Include his own name in the advertisement. C. Mention how many offices the franchise has in California. D. Both A and C. Correct answer is B. Include his own name in the advertisement. Real estate advertising regulations generally require that even when using a franchise or company name, the broker's own licensed name must also appear in the advertisement. This is to ensure transparency and accountability. While the franchise affiliation can be highlighted, it cannot obscure the identity of the responsible broker. Question 49. An option is different from other contracts, such as conventional or conditional sales contracts. The difference is due to what characteristic of an option? A. Irrevocability. B. Mutuality of obligations of the parties. C. Non-mutuality of obligations of the parties. D. Both B and C are correct. Correct answer is C. Non-mutuality of obligations of the parties. The key difference between an option and other contracts lies in the mutuality of obligation. In a typical sales contract, both the buyer and seller have obligations. The seller must convey the property, and the buyer must pay the agreed-upon price. With an option, only the optioner, usually the seller, is bound by the agreement during the option period. The optionee, potential buyer, has the right but not the obligation to purchase the property. The optionee can choose to exercise the option and buy the property, or they can let the option expire without any obligation. This lack of mutual obligation during the option period is what distinguishes it from other contracts. Question 50. Operating a factory on his property, the owner decides to sell the property and then immediately lease the property back from the new owner to continue operating the factory. This practice is called A. Reverse sale. B. Sale leaseback. C. Real property interest swap. D. Such a practice violates the UCC. Correct answer is B. Sale leaseback. A sale leaseback is a financial transaction where a property owner sells their property and then immediately leases it back from the buyer. This allows the original owner to free up capital tied up in the property while still being able to use it. It's a common practice in commercial real estate. Question 51. In an agricultural community, the severe drought has caused a collapse in income among most residents. Consequently, home values have also fallen drastically, a condition referred to as A. Functional obsolescence. B. Economic obsolescence. C. Simultaneous stagnation. D. Concurrent valuation. Correct answer is B. Economic obsolescence. Functional obsolescence is a loss in value due to outdated design, inefficient use of space, or other features that make a property less desirable or useful compared to newer properties or current market standards. It's a problem within the property itself, not caused by external factors. Essentially, the property is outdated or poorly designed for its intended use. Economic obsolescence is a loss in value due to factors external to the property itself. In this case, the drought and resulting economic downturn in the community are external factors that have negatively impacted property values. It's not related to the physical condition or design of the homes, functional obsolescence, but rather the economic conditions of the area. Question 52. The statute of limitations for filing a lawsuit for encroachment is A. 3 years, B. 4 years, C. 5 years, D. 7 years. Correct answer is A. 3 years. The statute of limitations for encroachment in California is 3 years. This falls under the statute of limitations for trespass or injury to real property. Question 53. The unities of title needed to create a concurrent estate, joint tenancy, tenancy by the entirety, tenancy in common, are A. Unity of time, unity of place, unity of estate, unity of interest, unity of space. B. Unity of possession, unity of property, unity of interest, unity of estate. C. Unity of time, unity of title, unity of interest, unity of possession. D. Unity of purpose, unity of possession, unity of title. Correct answer is C. Unity of time, unity of title, unity of interest, unity of possession. There are 4 unities of title, grouped under the acronym of TTIP, title, time, interest, possession. Here's what each unity means. Unity of possession. All co-tenants have equal rights to possess and use the entire property. Unity of interest. All co-tenants own equal shares of the property. Unity of title. All co-tenants acquire their ownership interest through the same deed or instrument. Unity of time. All co-tenants' ownership interest vested at the same time. Question 54. After property has been transferred either voluntarily or involuntarily, the method of safeguarding the new owner's interest in it is called A. Land protection, B. registration, C. recording, D. property preserving. Correct answer is C. recording. Recording a deed or other relevant legal document in the public records is the standard way to protect a new owner's interest in real property. A recorded document is placed in the public record of the county where the property is located. Question 55. A sworn statement in writing made before an official authorized to administer an oath is A. Declaration, B. affidavit, C. acknowledgement, D. testimony. Correct answer is B. affidavit. A declaration is a formal statement or announcement, often in writing, that can serve various purposes. It can be an official pronouncement of intent, a sworn statement of facts, sometimes used like an affidavit, or, in real estate, the document establishing CC&Rs. Essentially, it's a clear and significant statement of something important. An affidavit is a written sworn statement of facts. It's made under oath before an authorized person, such as a notary public, and is often used as evidence in legal proceedings. It provides constructive notice of the transfer, making the ownership change a matter of public record and helping to prevent future title disputes.